Supreme Court justices are, with very rare exceptions, not trained historians. And historians and judges do very different things. Historians can revel in the unexpected twists and turns of the past, can enjoy its ironies and its contradictions. But the men and women on the court have to make final decisions about what it all adds up to. In District of Columbia versus Heller in 2008, Justice Antonin Scalia, writing for the court, at times sounds like a historian. He attempts to show that the Second Amendment had a particular meaning at the time of its ratification in 1791 and thereafter, a meaning that should determine what the right to keep and bear arms means today. Legal scholar Cass Sunstein calls it the most explicitly and self-consciously originalist opinion in the history of the Supreme Court. Justice Scalia embraces what has been called a new originalism. Unlike the old originalism, the new originalism is a search not for the original intent of the framers and ratifiers of the Constitution, but for original meaning. That is, how the Constitution would have been understood by people living at the time. So in the opinion of the court, in D.C. versus Heller, Justice Scalia seeks to determine, and these are all phrases that he uses, the familiar meaning, 18th century meaning, normal meaning, ordinary meaning, normal and ordinary meaning, original meaning, true meaning, basic meaning, central meaning, and natural meaning. Now, how would a historian attempt to determine these things? Here's the short version of what historians do. Historians confine themselves to the evidence at hand, they contextualize that evidence, and they periodize their conclusions. The first part goes almost without saying. Historians write about the past, and they could care less about coming up with some kind of theory that has predictive value. More important, historians contextualize the evidence. It was intellectual historians in the 1970s who first made good use of the noun context and turning it into a verb, contextualize. They knew that failure to contextualize would inevitably lead to anachronistic understandings of the past. But even more than this, historians periodize. What that means is they determine how precisely a particular historical period is different from what came before and from what would follow. It's this that separates most Supreme Court justices' efforts to do history, such as the opinion of the court in D.C. versus Heller, from what historians actually do. For example, Justice Scalia contends that clauses in state constitutions written before 1789 that mention the right to bear arms support his reading of the Second Amendment as protecting an individual's right to bear arms for his own defense. He quotes from 4 state constitutions that were written before 1789. Pennsylvania and Vermont have the same clause, that the people have a right to bear arms for the defense of themselves and the state. North Carolina, that the people have a right to bear arms for the defense of the state. Massachusetts, the people have a right to keep and bear arms for the common defense. 3 short paragraphs later, in his opinion, he astonishingly says the following: "We believe, therefore, the most likely reading of all 4 of these pre-Second Amendment state constitutional provisions is that they secured an individual right to bear arms for defensive purposes." How had he gotten there? The answer is simple. He found a North Carolina judge and a Massachusetts judge, writing in 1843 and in 1825 respectively, so 52 years and a more respectable 34 years after the ratification of the Second Amendment, who decided that the state constitutional rights in question should be interpreted to protect an individual right to own weapons for self-defense. Now, deferring to state-level decisions such as this, made regarding state constitutions, is, one would think, good law, good legal practice. But it's not good history. It tells us nothing about what a constitutional provision meant at the time of its ratification. Historians know to periodize, that is, to find ways to determine when meanings, common conceptions, ways of looking at the world had undergone real change. And simply put, over the course of just the 1790s, the first 9 years of the Second Amendment's constitutional lifespan, people of almost all political persuasions had begun to think differently about the logic that underlay constitutional protections of the right to bear arms. As historian David Koenig has shown, Americans, and Thomas Jefferson is a perfect example here, began to think that there were other checks on the potential abuse of power that were far preferable to armed resistance. Soon, most Americans did not see the militia as an effective or even a necessarily legitimate way of resisting governmental tyranny, and these changing interpretations of constitutional protections for the right to bear arms would reflect this shift. Back in the 1780s, The idea of the armed resistance of the people was something that Jefferson saw as a necessary, treasured safeguard against governmental tyranny. Shays' Rebellion in 1786, which was an armed, popular uprising in Massachusetts just before the Constitution was written, prompted Jefferson to say, and it's now famous, "I like a little rebellion now and then. It's like a storm in the atmosphere." But just 13 years later, the Alien and Sedition Acts, some unquestionably bad federal statutes that violated individual rights to free speech and a free press, saw Jefferson writing to his friend Edmund Pendleton about how wrong-headed it would be to resist these tyrannical federal laws by force of arms. He said, and it's a wonderful quotation, "In this state, we fear that the ill-designing may produce insurrection. Nothing could be so fatal. Anything like force would check the progress of the public opinion and rally them around the government. This is not the kind of opposition the American people will permit, but keep away all show of force, and they will bear down the evil propensities of the government by the constitutional means of election and petition." Shortly thereafter, Thomas Jefferson was elected president over John Adams, and political means of righting wrongs, of resisting tyranny by the peaceful transfer of power, was planted firmly in the American mind. Some 3 years after that, judicial review joined the array of legitimate ways to resist bad government. With the militia's original purpose fading from the public mind, but with newly available, newly dangerous weapons becoming the subjects of gun control legislation in the 1820s, it should be absolutely no surprise to us that Justice Scalia can find abundant quotations from the 1830s in which people describe the rights of individuals to own guns for their own self-defense. And thus the meaning of a right to keep and bear arms, as understood in the Jacksonian era of the 1820s and the 1830s, is in fact great evidence of what it was not in 1791. A lawyer can and should look to subsequent layers of interpretation and legal precedent. Historians are more attentive to how words spoken at one historical moment might have had meanings, implications, connotations they would not have had a generation or even a handful of years later.